And everyone can please go on mute until, time for you to speak. That would be great. Good morning, everyone. We will be starting in just a moment. Make sure to have something to take good notes on. This should be an informative class, and we'll be asking you some questions as well. So thank you all for joining today. We're going to start in about 30 more seconds. A few more folks coming in. All right, good morning, everyone, and thank you all for joining PCR SBDC as we have our U.S. Patent and Trademark Office, USPTO series. This is our third in a series, and what a great topic to end on here on Trademark Basics. So we're so excited that you all could join us today. This subject is what every small business should know now, not later. So we appreciate you all joining today and hope that you'll get some very important information that will help your business along the way. And thank you guys all for showing yourselves. It's nice to see some live and smiling faces on the line. I see you, Kim and Amy and A. Couture and Chanel. Thank you all so much. We do ask if you would just make sure to keep yourselves on mute. And then if you are moving around, please put yourself off screen because it makes me dizzy. So if you guys have to get up and move around, no problem. Just take yourself off screen and then come back on. That would be good and will help all of the rest of us to keep our focus. So for those that might be new to the SBDC, we're so happy that you joined today. Our role is to help businesses to start, grow, survive this pandemic and succeed. And so we're so excited to be able to do that. We are one of 1,000 locations in the country. And of those 1,000 locations, we are a proud partner with the SBA, the Small Business Administration, to help with business and economic development for small businesses in the community. And PCR is local here to the LA area, and we mostly handle LA County, though we do extend, especially during COVID. We've been here to help whoever has needed help. What we do, so we're providing business consulting, training, and resources for small businesses. That includes one-on-one advisement and workshops and webinars like this, doing business planning, management, marketing, legal, and like today's subject on, it's kind of a mix of marketing and legal as it relates to trademark and trademark protection. All of this is no cost and no catch to you. So it is your good tax dollars put to work for your benefit. And so we are happy that you are here to take advantage of that. I'm going to be putting in the chat for those of you that might need an advisor, a business advisor. I'll be putting into the chat shortly the information and how to reach out to us, and feel free to send an email to that particular inbox I'll put in. If you need a business advisor to work out your plan and to help with your meeting your own milestones. So I'm Colette Moore. I'm the director of PCR SBDC. I am a previous business owner, had a business for 8 years doing staffing with a franchise. And prior to that, I worked for Disney as a VP in marketing. And so so happy to be able to be here to help small businesses, because I want you all to maximize your opportunities and minimize your mistakes. So that's what today is about as well. So how can you capitalize on everything in front of you. And so that is one of the reasons, our team is very active to try to give you good information as well. We also have joining us today, Jason Lott. Jason is an attorney advisor for trademark educational outreach for the USPTO, and he specializes in small business owners understanding trademarks and federal trademark registration process through live presentations, videos, multimedia platforms. He's been with the USPTO since 2000, and has also previously served as an examining attorney. You'll learn more about that. And he's a recipient of the Bronze Medal Award, the Exceptional Career Award, and multiple customer service awards. Mr. Lott, Jason, has earned his JD in 2000 from the Dickinson School of Law in Pennsylvania State University, and he has his BA. He's a smart guy, magna cum laude, 1997 from Kenyon College, and he was admitted to the bar. And so our second speaker for today is Stella Mittelbach. And this is Stella's second time joining with us. We're so happy to have her because she's a local resource that we didn't know about until very recently. So Stella is an acting senior librarian in Science and Technology and Patents Department with the Central Library in downtown Los Angeles. She's worked for LA Public Library since 2006. And when she's not working, helping independent inventors and entrepreneurs to find patent and trademark resources and information, she's working to develop her department's exceptional culinary collection. And so that's another area we can, again, work on with our Restaurant Academy as well. So we're so excited to have this group with you. Stella presented information last time, but she's got some specific trademark resources this time to be able to assist our clients. With that, we're going straight in with our USPTO and Jason Lott. And Jason is going to switch in his screen and we're all good. And get ready, get your pens ready, take some good notes, and we're going to get started. Jason, all yours.
All right, thank you very much. I do need to remember start video here so you can see my big forehead. That's very important. That's key to this whole thing. So hey folks, my name is Jason Lott. I am the attorney advisor for Trademarks Customer Outreach at the USPTO. And it is my job to teach you about trademarks. And before I do that though, we have a couple of poll questions to sort of, well, actually maybe it's just one to start off with. So Briajani, would you mind throwing that up there? All right, I think it's a real quick poll, so make sure you put your answers in there, and then we'll see what the results are. Okay, all right. So we have novice, basic knowledge of trademarks, and competent to explain trademark processes. Okay, cool, great. We have a nice little mix here. I'll admit, I said expert in the field, but that's just because I had to. You know what I mean? Just because I've been doing it for a while. So okay, so this is great. This is perfect timing for you folks to learn lots of trademark basics. And if you already know some of these things, that's great. Hopefully, we're going to supplement that information and you can use that to help you in your business. So we're gonna go through a couple of things today. First of all, we're gonna talk about like what a trademark is, okay, and the sort of different variations or different forms of a trademark that there could be. We're gonna talk about why you might want to federally register your trademark. We're gonna talk about how to select a strong mark. We're gonna talk about some of the basics of filing and registration, and of course, we have to end with resources, and we're going to talk about how to find help, because as you will see, the process can be a little bit complex, so you have to make choices, you have to make decisions. And sometimes you're going to want a business advisor or an attorney or a librarian to help and guide you in terms of looking at resources and learning information. So we're going to talk about some of those as well, including free and reduced price legal services, because, attorneys can be expensive. All right. So first things first, let's talk about definitions and trademarks. Okay. So this is what I like to show first, because sometimes people get all confused about trademarks and copyrights and patents, and they want to patent that copyright on the trademark or trademark the copyright on the patent, things like that. So it's very important that you understand what a trademark is. And I think that all of us inherently now, because we're modern consumers, know what a trademark is. So if we take a look at this slide up here, this is a graphic that's put out by Interbrand. It's a private company that does private valuations of trademarks. And they have some, I don't know, proprietary algorithm that helps them figure it out. But one of the reasons that I love this slide is because it shows you right away what a trademark is. So let me know if I need to stop. Okay. So if you take a look at this, and if I was to say BMW, what do you think of? Cars, right? If I say McDonald's, what do you think of? Hamburgers. If I say Nike, shoes, UPS, delivery services, Coca-Cola, soft drinks, Apple, phones, right? So every single time you hear or see a particular trademark, it automatically makes you think about very particular goods and services that are associated with that trademark. And that is key. All right. You have to understand that a trademark, a brand, a slogan, a logo, things like that, they are always tied to very specific goods and services. Okay. A trademark doesn't just cover everything in the world. It's always tied to specific goods and services. And the other reason I like to show you this graphic is because it shows you how important trademarks are. So if you take a look up in the top left-hand corner there for Apple, Interbrand has valued Apple's trademarks at $322 billion. Okay, Amazon, $200 billion. Microsoft, $166 billion. Okay, and that is just their trademarks alone. Right? It doesn't have anything to do with their actual buildings or actually the actual devices or the trucks that Amazon uses, none of that stuff. It's all their trademarks, all right? Which is amazing when you think about how much value there is in this sort of like nebulous, sort of intangible sort of property that you could have. And so I want you to be thinking about yourself as one of these folks, okay, as we move through the presentation. So let's talk about the legal definition of a trademark. Well, technically, it's any word, symbol, design, or combination of these that does two things. It identifies the source of goods and it distinguishes them from the goods of another party. And here's the easy way that I like to think about this. If you remember back in the times when we were allowed to go to a restaurant and sit down inside, or you can go outdoors now, but you go to a restaurant and the waiter comes over, says, "Would you like something to drink?" And you say, "Yes, I'd love a Coke." And the waiter says, "Is a Pepsi okay?" And that is a trademark in action. It is identifying the source. So in this case, the waiter is identifying Pepsi as the source of the beverage you're going to drink. And it's distinguishing from the goods of the competitor. So it's distinguishing from Coke, from Coca-Cola. Okay, so that's what's happening here. And that's a good usage and good understanding of trademarks. It is identifying the source of the goods and it's distinguishing them from the goods of another party. Now, the interesting thing about it is that a trademark and service mark, sometimes people get them a little bit confused, but the term trademark incorporates service marks. So technically a trademark is indicating the source of goods and a service mark indicates the source of services. But the great thing is you don't really have to worry about that, okay? You can just call them all trademarks. It's totally fine. You can actually call them marks. That's totally fine. You're going to hear me say mark all day throughout this presentation, just because it's an easy shorthand and it's easily understood. And actually under the law, you can refer to them as marks. So anyway, so trademarks and service marks, that's really sort of how it breaks down. But don't worry about that. You can just call it trademark. But understand that a mark indicates the source of particular goods and of particular services. Now, sometimes people ask, what about that TM, Jason? What about that SM? What about that little R in the circle? What the heck does that mean? Well, we're going to talk more about common law and federal registrations here in a little bit. But essentially, the way it works is this. If you are using something as a trademark to indicate the source of your particular goods, you can put a little TM after your brand. Or if you're using it for services, you could put a little SM after your brand. And that's totally fine. You can do that at any point. There is no requirement whatsoever. There's nothing you have to do. So long as you are intending to use that thing as the brand for your particular goods or your particular services, you can use that TM afterwards. And there's no font requirement and there's no placement requirement. You could put it at the front, you could put it at the back. Most people will put the little TM or the SM at the end of the trademark, often in a superscript or maybe in a subscript, but it's really up to you. You can kind of use it however you want to. So that's TM and SM. They indicate trademarks and service marks. The little R in the circle, however, is a little bit different. It also indicates that this particular thing is a trademark, but it is indicating that it is registered with the federal government. So the only time that you can use the little R in the circle symbol is after you have registered your trademark with our office. And we'll talk a little bit more in a little bit about the difference between trademarks and registration of those trademarks. But I wanted to make sure you have a little basic understanding of the TM and the SM and the R, because people do get confused about those things. All right, now most of you folks already know the difference between a trademark and a patent, I'm sure, because you have attended previous seminars here, and so you already know this. So if we remember, a trademark is sort of protection for a brand. A patent is granted to help you protect your new invention. And so we're talking about technical things. A copyright is going to be protection for an original artistic or literary creation. So think about songs and movies, books, paintings and sculptures and things like that. All the artistic creative stuff that is protected by a copyright. And it's all a little bit different than a trade secret, which you probably learned about last time, which is really protection of information that you just don't want other people to know because it has a business value. Right? So the KFC recipe, the Coca-Cola recipe, Mrs. Fields cookie recipe, I think Listerine, WD-40, nobody knows how you really make those things, okay? That's all protected by trade secret. And oftentimes folks get that confused, all these different words, because they kind of sound the same. And you've kind of heard them used in I mean, shoot, our office is called the United States Patent and Trademark Office, right? So people are gonna be like, yeah, there's gotta be a connection between those two things, right? So they're all work together, but they don't necessarily, but they all have different things that they protect. So trademarks are gonna protect your brand, patent is gonna protect your invention, copyright is gonna protect your sort of artistic or creative work, and a trade secret is something that you just keep secret to make sure that you can protect that value that it has and don't let anybody else know about it. So one thing that sometimes folks get confused by is they say, okay, what am I supposed to do? I have my business name. Do I protect that? How do I do that? What about my logo? And what about my slogan? And what about my this? And what about my that? Right? There's a lot of confusion out there sometimes about what am I actually trying to protect with a trademark? What am I using to use as the indicator of source of my particular goods and services? Well, this slide right here, the intent of this is to help you understand all the different variations that you have at your disposal. Right? Because it is up to you what you want to use as your trademark and how you want to protect your trademark. So the way it kind of works is this. There are what are known as word marks, and there are what are known as special form marks. So a word mark is going to give you protection for just the wording alone. So as you can see here, Coca-Cola has registered Coca-Cola, and they are just protecting the wording itself. Not what it looks like, but just the wording alone. And that means that over the life of the trademark, they can use Coca-Cola in whatever form, like any font or style or color or size they want to, and they are protected, right? It's an incredibly broad scope of protection because it's protection for the wording itself and not what it looks like. And you have as an option, if you want to protect the word version of whatever it is that you are using as a brand for your particular goods and services. And it's the real thing is there just as a slogan, because sometimes people get confused. It doesn't matter if it's one word or multiple words, it's all the same. It's all considered a word mark, a standard character mark. All right, so that's the word marks. And that's different from our what are known as special form marks. In our special form marks, what you're doing is essentially protecting some visual thing that's happening in your trademark, okay? So it could be stylized, such as Coca-Cola protecting the wording in the font and in the particular red color. It could be composite, where you're combining wording in a design, or it could be just a design by itself. All of those are different options for ways that you might go about trying to protect your trademark, because it boils down to what is most important to you. All right. So remember, word mark, that's wording for itself, wording alone that you're protecting. And then our special form marks, you're protecting a little something extra there. Okay. So, but let's take, for example, the stylized mark, Coca-Cola. It's written in font and it's written in red. All right. So when you register a mark in this way, you are in some ways limiting your protection, because what you're saying is, this is my trademark. It appears like this, and in this case, in this particular color. And that means that technically, Coca-Cola's protection is only for the wording Coca-Cola in that font and in that red color. Now, let's say it's St. Patrick's Day, right? And they want to use that mark in green. Are they protected based upon a registration for that? No, not technically, because they've only protected it in the color red. Now, am I suggesting to you that you should go out right now and try to register Coca-Cola in that font and in green? No, of course not. And why? Because Coca-Cola has also registered Coca-Cola as a standard character mark, right? As that word mark, and that gives them that broad scope of protection, and they can use the wording however they want to, including in their font and in the color green. All right, so that's just a little example to show you how sometimes the limitations are put in place when you apply to register a mark that is stylized in some way, or contains a design element, or contains color. And we'll talk about some other options more about that here in a little bit. So these are traditional types of marks, okay? The things that you typically see, a brand name, right? Or a logo. But there are other non-traditional types of marks that can be registered, such as sound. You know, for example, NBC is registered bum, 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 right? Whenever you hear that, when you're watching TV, you're like, oh yeah, I must have the channel on NBC, okay? Color, so if you think about fluorescent pink has been registered as a color for insulation that you put in your house. Scent and smell. So there is actually a company that has registered various fruit scents when used with lubricants and motor oils and things like that. So anytime you crack open that thing, strawberries, it must be, you know, so-and-so, right? So in that way, that is a trademark, which is indicating source. As soon as you smell it, you automatically know who it is that created those particular automotive goods. Motion is also registrable as a trademark. If any of you are J.J. Abrams fans and J.J. Abrams, and you see Bad Robot before a TV show or before a movie, and there's the robot that goes through the cornfield, yeah, registered as a trademark. Every time you see that, you're like, oh, that's Bad Robot. Yeah, great. Same with holograms and configurations and things like that. So configurations, think about the Coca-Cola bottle. That has been registered as a trademark. You see that contour shape of the Coca-Cola bottle. You walk in the 7-Eleven, you see it in the cooler right across the way. You're like, yeah, that's where the Coke is, right? Because it automatically calls to mind in your head when you see that particular thing, that must be a Coca-Cola. Right. So I just want to sort of expand your understanding of trademark. So it's not just a name or a slogan or a logo. There are lots of things that can function as trademarks. It all depends on you and what you want to protect as your trademark. So sometimes folks do get a little bit confused. They see that they say that they've registered their domain name. Right? They say, oh, Jason, so I've registered such and such as my domain name. That means I have a registered trademark, right? And the answer is no, it doesn't. Okay. That is just registering your domain name in order to have, you know, a web address and a place for people to find you online. That is different from registering a trademark. And the same thing is true with a trade name. Now, sometimes folks would refer to it as a business name or a company name. Sometimes people call it a DBA, you know, things of that nature. So, but that's also different than a trademark registration. That trade name is just what you register, say, with the Secretary of State here in California in order to do business in California. That is completely different from a trademark or a trademark registration. Now, people will say, yeah, but can I use my business name as my trademark? Do I have to? What about my domain name? Can I use that as a trademark if I want to? And the answer is, yeah, you can if you want to. It is up to you, however, and you don't have to. All right, so let's take a look at an example here of one particular company that is using a particular set of wording as both a domain name and as a trademark. Right. As you can see up in the top left-hand corner there, we have lowrates.com circled in red, and that is being, you see it there in the address bar, is being used as a domain name. They have also registered it and are using it as a trademark. So as you can see in the red circle there at the top of the page in the center, they're using it in a trademark manner in the middle of the website. All right, so if you go on this website, you would see, oh, lowrates.com, that must be the brand of these particular, yeah, I guess it looks like mortgage rate services. All right, Amazon.com used to be the, the best example of that, probably in the early 2000s, because it was both a domain name and the trademark, where you knew that you went to buy your books and diapers and automobile tires and everything you can buy on Amazon. Okay. So that's the difference between domain name and trademark use. Are they the same thing? No, but they can be. It all depends on how you use it. And the same thing is true for a trade name. All right. So if you want to use your business name that you registered with the Secretary of State as your trademark, you can. It is up to you if you want to, but you don't have to. You could have a really boring trade name and a really cool trademark. All right, it's your choice. So let's take a real quick look right here, and we can see the difference between something being used as a trade name and something being used as a trademark. If you look down in the bottom right-hand corner, you can see Philly's Best Steak Company, Inc. It's down there circled in red. They're based out of Yearden, Pennsylvania. And as you can see there, it's being used as a trade name. It's just essentially kind of telling you sort of the address and where the company facilities are located. So that would be trade name usage. Up in the top left-hand corner, however, circled in red, you can see Philly's Best Steak Company, Inc. being used as a trademark. So every time you see that, that must be the source of my, Philly Pounder Premium Beef Sandwich Steaks. Okay, you can see very clearly it is being used to say, hey, consumer, look over here, look at me. I'm what you want to purchase because I'm the best source of these of cheesesteaks, essentially. Okay, so that's kind of the difference between use in a trade name and use as a trademark. And again, just like domain names, it is up to you. You could have a boring thing like, Jason's Company LLC as a trade name, and you could have something super awesome. I don't even have any idea what that would be as a trademark. Google actually is a great example of that. Alphabet Inc., I think, is what they have as their trade name, but they have registered Google as a trademark, along with YouTube and all the various other things that Google has. So that would be a good example of a difference between the two, of somebody using one trade name as the business name and something totally different as a trademark. Okay, so now that we know what trademarks are, we want to know why in the world you would want to go through the process of trying to register that trademark with the USPTO. So before we talk about that, let's talk about how trademark rights are created. All right, and they're created in two ways. One is under common law, and then one is under federal registration. Common law trademark rights are essentially created as soon as you start using a trademark to indicate the source of your particular goods and services. And those rights are created under state law. And you don't have to do anything special. All you have to do is use that trademark. And if you want to, you can throw the little TM or the SM after there to let folks know, hey, everybody, I'm claiming this is my trademark. I'm using it as a trademark. Please don't use it, okay? So you can do that automatically. It's totally fine. There's nothing special that you need to do. The problem is that your rights that you create are typically limited to a geographic area. All right, so let's say that I'm starting my business. I've got Jason's Donuts, and I'm only going to various farmers markets in the Los Angeles area. All right, and I'm not advertising online. I'm not advertising in Bakersfield or in Barstow or in Sacramento or in San Francisco. It's only in the very tight Los Angeles area. Okay, so that means technically my trademark rights are only limited to that very specific area, in sort of Los Angeles. Right. So what happens if somebody in Texas is all of a sudden opens their own Jason's Donuts donut shop, and they're not just selling out a farmer's market, but they're open up, brick and mortar buildings and things like that. Well, that could be a real problem, right? Because I am planning to expand Jason's Donuts beyond just the farmer's markets, and I want to be selling nationwide and eventually, start selling abroad. All right. Well, what's going to happen here is that this other guy in Texas is going to be creating his own rights, right? Even though I started first, my rights are limited and they're only limited to Los Angeles. And I don't want that to happen because I want to be able to expand and grow my business, right? So I need to be thinking about getting protection nationwide and not just in a very small geographic area. So what I might consider doing is applying to register my trademark with the USPTO. And essentially what you're saying is, hey, USPTO, I'm using this trademark and I want to get nationwide protection. And if you are registered, if you are able to register your trademark, you get all kinds of rights, right? So those rights are created as soon as your trademark registers with us. It creates a legal presumption that you own the trademark, that you are the owner of that trademark. And it creates a legal presumption you have the right to use that trademark throughout the United States and its territories. Now, note, it is just US based and territory based, okay? It is not Canada, it's not Mexico, it's not anywhere in Europe or in Africa or in Asia or anything else, okay? It is only in the United States. If you want protection outside of the United States, that's a separate step and you have to register your trademark in those various countries. If we have time today, we can talk very briefly about that. It's something to have in mind, but for the most part, probably not something you have to worry about at this point. Maybe you do, but for most folks, it's not something to have to worry about just yet. Now, in addition to that, you can also claim notice to the public of your rights in the trademark. And essentially that kind of happens because your trademark goes in our database, right? Which means that everybody in the world can access it 24/7 for free. And they can look and say, oh man, somebody's already tried to register Jason's Donuts for a donut shop. Oh, well, I'm going to have to come up with a brand new trademark because I don't want to run afoul of that guy. Okay. So it's putting the public on notice. Hey, this is my trademark and I'm using it with these particular goods and services. The other great thing is you can bring legal action concerning your trademark in federal court. All right. So let's say I'm here in Los Angeles. I got my Jason's Donuts business and I hear about that guy in Texas is like starting to use Jason's Donuts for his own donut shops. All right. And I have registered my trademark and I have nationwide protection. Now, if I didn't have that, I would need to go to Texas and I would need to sue that guy in Texas to stop him from using Jason's Donuts. And that means I'd have to, fly there and stay in a hotel and get all my meals and probably rent a car and get a local attorney and, think about all those expenses that are there. Not so if you have a federal trademark registration. Instead, what you can do is file a federal lawsuit concerning your trademark here in Los Angeles, okay? Right? And that means that you can make Texas come to you. So he's got to do all of that stuff. So it is a great and efficient way for you to knock down potentially infringing users because you make it really expensive for them to try and defend what they're doing when you have all the rights, right? So that's a very cool thing. You can also record your registration with U.S. Customs and Border Protection. And this is incredibly important if you happen to be working in an industry where there are lots of infringing goods, counterfeit goods that are coming in from outside of the country, right? So if you record your registration with CBP, they will try and stop your goods from entering at the borders, all right? They're gonna crack open a container and, stop whatever ship, all that sort of stuff, right? Do all the really cool stuff that, shows up in movies. And they can try and stop those infringing goods from actually entering into this country. That's a really great benefit. And if you do want to expand your business beyond the United States borders, you can use your registration as a basis for filing in another country. We probably won't have time to dig into it too much today, but I just want to let you know that is possible. You can extend the protection into other countries, right? And of course, the coolest thing of all, you can use the R in the circle symbol, which is what everybody wants because that's the gold standard when it comes to trademarks. All right, so now we know what a trademark is. We know why you would want to get federal protection for your trademark. Let's talk about selecting a strong mark. Because even though it is our mission at the USPTO to register any trademark that is eligible for registration, we want to register your trademark, we have to examine it. And so that means that it has to comply with various laws and regulations. So that also means that not every trademark is going to be registrable and not every trademark is going to be enforceable. So before you apply, we want to make sure, and you're going to want to make sure that your trademark that you are using or are intending to use is going to be both federally registrable and legally protectable. Because this is one of the things that blew me away when I first realized that this was true. You could go through the whole thing of registering your trademark with us, and still somebody else could assert rights that are stronger than yours and stop you from being able to use that trademark, and they might be able to cancel your registration. And that's because they have prior rights in the mark, right? They have very strong common law rights, even though they never registered it. Right? So like you want to know about that, right? Before you apply to register your trademark, you want to know, is anybody else out there using the same or similar mark for related goods and services, right? Because that could stop you later on. So what I'm going to talk about next are two main concepts, and both of these things will go a very long way to help you learn about what else is out there and to be able to pick a strong trademark, which is going to be easier for you to defend if you need to. So the first thing we're going to talk about is likelihood of confusion. And the way that breaks down is essentially like this. You sometimes hear about it, people talk about infringement, about a trademark infringement, somebody's infringing on another trademark, right? So that's really what we're talking about here, but we're talking about it in the context of our office, of the USPTO. And that means that somebody, so let's say you have applied to register a trademark, and so we have to check and see in our database, is anybody else using a trademark that is confusingly similar for related goods and services? All right, so we are going to be doing an analysis. We're going to be doing an examination of our database looking for that. And it's really that two-pronged test. Are the trademarks similar, and are the goods and services related? All right, let me break that down just a little bit because that can be kind of confusing, and it's so important that you guys understand this, okay? So let's talk about, are the trademarks confusingly similar? When we talk about that, are we saying that the trademarks have to be identical? No, we're just saying that they are similar, okay? And that means they could look alike, they might sound alike, they might have a similar commercial impression, or maybe a similar meaning. Right. So when you see the two of them, like you're looking at it, you're like, wait a minute, which one is that? It's kind of like that, right? So you're confused because they're so similar to each other that they kind of mean the same thing, or they sound the same when spoken out loud, that sort of thing. All right. So that's that first part of the test. We're looking, are those trademarks, are they confusingly similar in some way? And the second part is we look at goods and services. Are they related? Because remember, as I said, every trademark is always tied to particular goods and services. So you do that analysis and say, does one company typically create or make both of these types of goods? Or does one company typically provide both of these types of services? And if so, that means the goods and services are related. All right, so that's the analysis. We're looking, are the trademarks similar? Do they look like, sound alike, similar meaning? And are the goods and services related? Are they perhaps complementary or typically made by the same company? Or sort of sold in the same trade channels, things of that sort. And if both of those things are true, a trademark is likely to be confused registration at our office. And you don't want that to happen, and we don't want that to happen. So what you want to do is search our database to see, is anybody else out there doing that? All right, so that's the basics of likelihood of confusion. What I want to do right now is a poll to see, based upon that information, whether you folks think that there is a likelihood of confusion in this case, okay? So you have like 20, 30 seconds, true or false, there is a likelihood of confusion in this case. And I'm going to answer as well, and I hope I get it right. Okay, all right. So we say 85% of people say a likelihood of confusion here, 15 say false. Okay, cool. All right, so let's go through the analysis. Great job, by the way, folks. So let's go through the analysis. Are the trademarks in this case similar? Is Exceed similar to Exceed? Yeah, right. Even though they don't look alike and they probably don't have the same meaning or commercial impression, they sure sound alike. So if I said Exceed, which one did I say? Who knows, right? It could be either one of them. So in this case, there is a likelihood of this first prong is fulfilled because the marks are similar. And so then we move on to the second prong. Are the goods related? Does one company typically make both agricultural seeds and, oops, here we go, Agricultural seeds and live plants? And the answer is probably yeah, right? You go to a garden center, you're probably going to find one company that is putting their brand on both seeds and on live plants. Burpee, right, probably does tomato plants and tomato seeds and things like that, right? So in this case, yeah, there's going to be a likelihood of confusion because the marks are confusingly similar and the goods are related. All right, so great job on that one. Just one more pop quiz. Let's see how you do with this one. Who says that there's a likelihood of confusion in this case? If you could, okay, cool. All right, probably a couple more seconds here. Let's see what you got. Ooh, interesting. Okay. So 10% of you said there is one, but most of you, however, said that there is not. All right. I will admit it's a little bit of a trick question, but please don't feel bad because that's the point of it. Okay. So in this case, there technically is a likelihood of confusion. So let's go through the analysis. All right. We'll do the easy part first. Pants and shirts. Does one company typically make both pants and shirts? Yeah, right? Clothing companies are always making pants and shirts and hats and socks and shoes and jackets and sweatshirts and all that sort of stuff, right? So when we're doing our analysis, let's do the easy one. Are the goods related? Yes. So we move on. Are the marks similar? Does Lupo look like wolf? No. Does it sound like wolf? No. Does it have a similar commercial impression? No. Does it have a similar meaning? Yes, it does. Because lupo in Italian means wolf. And so that means in this case, there is a likelihood of confusion because they have a similar meaning. Right now, I understand that is a little bit of a trick, okay? But it's something to keep in mind, especially if your trademark incorporates wording from another language. If that language is likely to be translated by an appreciable number of people within the marketplace, or whatever the actual legal test is, it's something similar to that, then in that case, yeah, there's going to be a possibility of a likelihood of confusion because people are going to translate that. So if you happen to speak Italian as well as English and you go into a store and you look and see, oh, there's the lupo pants and the wolf shirts. Yeah, that's probably, that is wolf. So it's probably just they're doing the same thing. So there's a likelihood of confusion in that case because people who speak those languages are likely to be confused. And that is what we want to avoid. All right. So you need to be aware of that, especially if your particular trademark has foreign wording in it, non-English wording in it. And you're going to want to look to see, is anybody else out there using a same or similar mark for related goods and services? And is that mark the same or similar in another language? Right. So that's likelihood of confusion. All right. So it's something to keep in mind. And so what we suggest to make sure you know about all this stuff is you do what is known as a clearance search. And what we want you to do is look in our database, okay? So you're gonna look in TESS, the Trademark Electronic Search System. And Stella's gonna talk about that here in a little bit. That is something she has knowledge about. So you can learn more about searching in TESS. So you need to search in TESS. We would also recommend that you look online. Okay, so you're looking to use Google and Bing and Yahoo and whatever else search engines are out there and look and see, is there anybody who's using a same or similar mark for related goods and services? And if so, that could be a problem. All right, so you want to do more research to figure out, is this person going to block me from being able to register my mark? And even if I do register it, is this guy going to come out of the woodwork and say, no, my rights are stronger than yours? You got to go away. Okay, so you want to do this sort of search. Now, it is possible to do it on your own. We often recommend that you do hire a private trademark attorney to do it for you because the attorney can do a full clearance search. Okay, she can search in our database, check those state trademark databases, check those business name registries, foreign trademark databases, check the internet, all the stuff that is just way too complex and too time consuming perhaps for you to do as you're running your business. So you might be able to have an attorney do it for you. And we'll talk more about hiring an attorney here in a little bit. So that's what we often recommend because it can get tricky. But if you want to do it on your own, those are the two things to do. Search in TESS in search online. All right. Okay, so that's likely to confusion, right? You don't want your trademark to be confused with someone else's. The other thing we want to talk about is strength of the mark. And I like to think about this as marks appearing on a gauge, okay, or something that goes from weak to strong or cold to hot. And we're talking about fanciful and arbitrary, suggestive marks, and then on down. All right. So the best marks, the strongest marks, the marks that are going to be easiest for you to protect are ones that are fanciful and arbitrary. So fanciful trademarks are words that are just made up. Okay? They have no meaning in English or in any other foreign language. So think about Xerox for photocopiers, or Kodak for cameras, or Exxon, for oil, things like that, right? So words that they're just made up. Okay, they don't have any meaning. Those are incredibly strong because no one else is going to have them, and they don't have any particular meaning, right? So it's not going to weaken them. Same thing with arbitrary trademarks, and these are words that do have meaning but have no relationship to the underlying good or service. So think about Apple for computers, or Gap for clothing, BlackBerry for mobile devices, right? If we see Apple these days, we typically don't think about the fruit. We think about the products, right? We think about the phones and the watches and the computers and all that sort of stuff. Okay, so in those cases, these companies have educated us. When we see this particular mark, we automatically think, computers, or we think clothing store, things of that nature. Okay, fanciful and arbitrary trademarks are great. They're a good way to go because they have they're going to give you a lot of protection. Now, just below that on the scale are suggestive marks, which suggest something about the goods and services without actually describing them, right? So think about Coppertone for suntan lotion. If you use this lotion, your skin will take on a coppery tone, okay? There's like a sort of step involved. It's not telling you that it's going to create a Coppertone skin, right? It's like a brownish skin, a bronzed skin. No, it's telling you it's kind of coppery. Okay, so it's suggestive in this case, and that's totally fine. Those are good marks. So suggestive, fanciful, and arbitrary marks, those are not going to be refused registration at our office based upon what is known as descriptiveness. Okay, so that's why we recommend it, because descriptive marks will be refused. Okay, you will get an office action from our office that says you may not register this trademark because it is merely descriptive of the underlying goods and services. So think about creamy whip for whip topping, right? You see that trademark, you automatically know, well, it's a whip topping, and in this case, it's creamy. All right, so it is not doing what a trademark does, which is indicate source of specific goods and services. It is just telling you something about the goods themselves, right? It is merely describing the goods. So it is possible to register descriptive marks, but you have to jump through a couple of hoops in order to do so. And you don't get a whole lot of protection for those because there are a lot of other people who are registering kind of descriptive marks, okay? So it's not going to be sort of like good for your business in the long term because it's going to be harder for you to protect. And what is below that there is generic. Those are never registrable. Like, you cannot register a word that is generic for the thing. Okay, so you would not be able to register milk for a dairy-based beverage, right? Because it is telling you what the thing is. It is not functioning as a trademark. It is just telling you what the product is, or telling you what the service is, right? So if it's, I don't know, landscaping services for landscaping services, that is never going to register because it is telling you what the thing is that is being provided by the company. And that's sort of how it all works. And so we always recommend fanciful, arbitrary, and suggestive trademarks because even though it may take you a little bit of time early on to educate consumers about your trademark and who you are and what it is you provide, more so than a descriptive mark, it's going to be better for you in the long run because they are easier to protect. All right, so I'm going to just hit filing and registration pretty quickly just so you can learn some of the basics. So if you have your trademark, okay, and you're like, yes, I've done all my searching and all my things like that. I want to register my trademark, just like Jason said, and I want to get that nationwide protection for my trademark. The way that you do that is, well, first things first, you have to create a myuspto.gov account. We have a sort of a login system now that requires you to create an account, which is actually kind of cool because it will have essentially is your intellectual property portfolio at the USPTO. So your trademark applications and registrations, your patent applications and things like that, it's all accessible in your myuspto.gov account. So create that first, and then use the trademark electronic application system called TEAS to file online. And just to let you know, you do have to file online. We have mandatory electronic filing these days. So you have to use TEAS in order to file your application. And you have a couple of options. There's TEAS Plus and TEAS Standard. They're two different versions of the TEAS form. And the reason I bring it up is because I want you to know the difference, because TEAS Plus is cheaper, okay? So as you can see here, the cost is $250 per international class. And the reason that you get the lower filing fee is because TEAS Plus forces you to front load all the information into your application, which makes it more efficient for you, and it makes it more efficient for our office. And so that means your application can move through the system more quickly because you've already complied with all the requirements. So to encourage you to comply with all the requirements at the very front, we are giving you a decrease or a sort of discount in the filing fee so that you'll file using TEAS Plus, and hopefully you'll be better off for it. Applications that are filed under TEAS Plus are like 2 times more likely to move more quickly through the process. And are less likely to get an initial refusal or an office action. So TEAS Plus is a great way to go. Now, you might be a little confused there by international class. Please don't be, because you're like, Jason, you specifically said that there is no such thing as like an international protection here. You said it's only in the United States. So what the heck are you talking about here with international class? All right. Well, international class essentially means that the United States has engaged in various treaties with other countries around the world. And as an international community, everyone has determined that goods and services are split into 45 different classes. So clothing goes in, is all in one class. Software might be in another. Online retail stores might be in another. Metal goods that are used as hand tools might be in one. Right. So things are split out into 45 different international classes, and your filing fee is dependent upon the number of those classes that are in your application. So if you have applied to register your trademark for donut shops, okay, that's in one international class. I guess that'd be probably 43, I think, for restaurants. And so you'd be paying $250 for Jason's Donuts, right, for the donut shops. So, but in addition to the donut shops, let's say you also wanted to register it for T-shirts and hats that you also sell at your donut shop. Okay, so you might register your trademark in 2 classes, restaurant services, right, in 43, but also in class 25 for the hats and for the T-shirts. Okay, so that would be the filing fee times 2. Even though there are 2 things in this other class, right? Hats and T-shirts are in class 25. You're only paying 1 filing fee for the goods that are in this single class, right? So in this case, it'd be $500 because you'd be paying for things in class 43 and the things in class 25. And that's kind of how that works. So the other thing, a couple things you need to know before you file, you need to decide which drawing type you want to try and register. Remember at the very beginning, talking about standard character marks and special form marks are drawings, right? So it is your choice what version of your trademark you want to apply to register. You could, if you want to, apply to register the trademark, just the wording alone. If the stylization is important, you could also register it as a special form mark, and and you would show your trademark appearing in that stylized or special form sort of format. And means you'd have to submit a JPEG drawing and things like that. Now, as you can see here, I've shown these marks in black and white. And why is that? Well, if you remember early on, I was saying, what about this trademark appearing in red, Coca-Cola written in red? But so it doesn't protect the mark written in green. Well, if you apply to register your special form, a special form drawing in black and white, you don't have to worry about color, okay? Because you're saying, hey, USPTO, I'm going to be using this trademark in all kinds of colors over the years. I'm not claiming particular trademark rights in my trademark being used in a particular color, all right? Which is a really great thing, all right? So what I'm going to tell you is not legal advice. Okay, I am not giving you legal advice. However, I can tell you that in all my years as an examining attorney and all my years working with small businesses, doing outreach, I've determined that folks do one of two things. If they want to protect the wording itself and get this really broad scope of protection for this wording, they will apply to register their trademark as a word mark using a standard character drawing. If for some reason there's stylization or design that is important that they really need to protect, they might apply to register their trademark through a special form drawing, but they will do it in black and white because it allows them to use that trademark in any color they want to over the life of the trademark. All right, so not legal advice, I'm just telling you what I've seen over the years. All right. The other thing you need to do before you file is make sure you identify your goods and services. You want to know what those are. What are the things that I use my trademark with, right? What are the goods that I provide? What are the services that I provide? And you're going to want to figure those out before you apply. And the way you do that is do some searching here in our trademark ID manual. Because we have to be very specific about the wording that is put into that ID. And we have to make sure it's generally understood. It should be specific, so broad, but also specific. So if you're using your trademark for like t-shirts that have a V-neck and they're black and they have rhinestones sewn on them, right? If you wouldn't have to try and find that in the ID manual because you won't, okay? Yeah, and you wouldn't have to put it in your application. Oh, I'm using my trademark for black V-neck short sleeve t-shirts with rhinestones on the front. No, not necessary. You could just identify your goods as t-shirts or shirts or even tops. Okay, and the reason that that's important is because, as you can see here, you cannot expand the scope of your trademark, of your identification after you file. So if you were to say, no, I'm only using my trademark for these black short sleeve V-neck t-shirts with rhinestones sewn on the front, and then all of a sudden you start using that on white V-neck t-shirts, or they're not V-neck, or they're not short sleeve, or you're not using rhinestones, well, guess what? You cannot amend your trademark application to expand the scope beyond that very specific thing you had in your ID. So what you want to do is try and have a broad yet accurate identification. So you could just say shirts, right? And then you could use your trademark with, really specific rhinestone t-shirts or not, or whatever it happens to be. So long as they're shirts, you're covered. Okay. The other thing you have to do is figure out your filing basis. So you have to, in order to register your trademark with us, you must be using it in commerce, so across state lines. So that's to register your trademark. That's different than filing, okay? You can file using use in commerce, right? So if you're already using your trademark across state lines, but if you're not doing that yet, but you have a bona fide intent to do so within the next 3 to 4 years, you can file under that basis and say, hey, USPTO, I'm not using my trademark yet, but I have a bona fide intent to do so within the next 3 to 4 years. Therefore, let's start my application process. And we will say, okay, we'll start the process, but remember, you cannot use the R and the circle symbol until you actually register. And you can only register once you are using your trademark across state lines or between a state and another country or a territory or something along those lines. Okay, so it's going to be up to you to figure out what your basis is. Are you using it across state lines, or are you just getting it in early because you know you're going to be doing it soon? It's your choice what you want to do, but just be aware if you file under the intent to use basis, you will have to file additional paperwork and pay additional fees. So that's something to keep in mind. All right, and these are just a couple of common bases for refusal. Likelihood of confusion, you already know that one. Descriptiveness, you already know that. Geographically descriptive, so if you're using it for Los Angeles donuts, okay, that's likely to get a refusal because the donuts are made and sold in Los Angeles, right? And the other ones get a little bit trickier. We don't have a whole lot of time to go into them today, but just be aware there are various reasons why your trademark could be refused registration. Also remember, it is up to you to enforce your trademark rights. There is no trademark police. We do not go around and say, hey, you shouldn't be doing that, right? It is up to you to enforce your rights. And once you have that registration certificate, you might be sending that, or your attorney might send that cease and desist letter, or you might, be suing that guy in Texas because he's infringing on your trademark rights. Now, there are a couple things to keep in mind. You do have to continue to file some paperwork after your trademark registers. All right. So just like you have to enforce your trademark rights, you also have to keep your registration alive. And there are a couple of things you have to do between the 5th and 6th years after registration. You have to file a Section 8 declaration of use that says, hey, USPTO, I'm still using my trademark in commerce. Here's an example of how I'm doing it. And then between the 9th and 10th years after registration, you have to file what's known as a combined Section 8 and Section 9 application for renewal. So it's again that, hey, I'm still using it. And also, hey, by the way, can I renew my registration? That's what the Section 8 and 9 essentially is saying. And that is due 10 years after registration and then every 10 years thereafter. Right. But the great thing about it is that, yes, you do have to keep this up. You have to continue to use your trademark in commerce, and you do have to continue to file your paperwork essentially every 10 years. But as long as you do that and you're continuing to use your trademark registration could last forever. Right. So you could be passing this down to your kids and your grandkids and your great grandkids and your great 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 grandkids. Right. Your business could go on forever and your trademark rights could go on forever, so long as you continue to use your trademark in commerce and file your paperwork. Now, there's another thing called a Section 15 claim of incontestability. I'm not going to go into it too much, but just be aware it's out there as something you can file to say, hey, I'm claiming incontestability of my registration, which sort of means that it can't be cracked. In some ways, if you go into court, it's not exactly true because there are some ways when it could be. But for the most part, you're saying this trademark registration you cannot attack its registrability, which is pretty sweet. And another thing to keep in mind is that your information will become public. That's part of the law. That's what happens when you file an application. Your information is put in our database, which is publicly accessible. So what that means is that there are folks out there who scrape our database. And they say, oh, all these people are not represented by attorneys. I'm going to send them a letter. In some cases, they're trying to trick you into paying money that you should not be paying, or they're trying to trick you into hiring them, or perhaps they're a legitimate company offering a service that maybe you need, maybe you don't need, but just be aware you are going to get stuff in the mail. All right. And it's going to look kind of scary sometimes, and it's going to be telling you to file paperwork that you do not need to file. So as you can see, there's a link right there. You're going to have access to a PDF of this slide deck. So you can just click on the link in there and take you to this webpage for trademark solicitations. There's a huge list and all the examples of the folks that are out there that are sending stuff that you don't want to respond to. So you can find information about that. You can also use the application serial number that you get once you file and look in our database through TSDR, the Trademark Status and Document Retrieval System, and you'll be able to see if it's something that we sent to you or if it's something that's coming from a scammer. Okay. All right. I'm going to hit very quickly how to find help because we want to get some questions, and also Stella needs to talk about the PTRC. So just very quickly, we have lots of great resources on our website. Be sure to check it out. We also have the Trademark Basics booklet, which is a downloadable booklet, which is everything I talked about today, but just in written form, because like Jason talks too fast. And that's only because we have so much to cover. But you can download that booklet at any time. There's lots of great information there. We also have lots of great trademark videos, which covers a lot of this information. You're going to see my greasy forehead in pretty much every one of those. So I'm sorry about that. But we have lots of different ways of learning. There's also the Law School Clinic Certification Program. So if you do need help with an application, you can apply to one of these clinics. You'll be working with an attorney who is running the clinic at the law school, and you'll also be working with a law student who's sort of learning as they go. And you will get that for free. Okay, so check out that link. There's about 60 law schools across the country that are part of it. And it's a great way to get essentially free legal services for help with your application. There's also the Trademark Assistance Center, which is our customer service folks, and they want to help you as much as they possibly can. So give them a call, shoot them an email. They do want to help. All right, so they can provide lots of general information for you. But keep in mind that the TAC, and as well as me, as well as no one at the Trademark Office or the USPTO in general, can give you legal advice. All right, it's all going to be general information, which you then apply to your specific circumstance. And we also don't enforce your legal rights, and we cannot recommend attorneys. But we do say your best resource might be an experienced trademark attorney and not a filing company. So, and here's a couple links here for various places where you could go to learn about more places to get free and reduced price legal services. So check that out when you get a copy of the slide deck. And of course, SBDCs. I always like to close with this slide because we are huge fans of SBDCs, and you know all about that. I don't have to tell you anything. We're also a big fan of the PTRCs, and Stella's going to tell you more about that. We're also huge fans of that, but I always put this in here because they are such a great resource, and we want people to use them. All right, so as I close it out, take one more look at this slide, okay? Take one more look up here, and let me ask you a very quick question. Do any of you see a generic trademark on here? Do you see a descriptive mark? Do you see a suggestive mark? No, you don't. Mostly it's going to be fanciful and arbitrary marks. Now there's other things that are up there like, names and stuff like that. But really what we're talking about here are fanciful and arbitrary marks. And so I would just say to you, if fanciful and arbitrary marks are good enough for brands that are worth in the hundreds of billions of dollars, they should be good enough for you. All right. Don't sell yourself short. Don't just pick a mark that's kind of descriptive and kind of whatever, right? Pick something that's strong that you're going to be able to use to help grow your business, because this is a great financial asset for you as your business grows. All right. So we're to the questions section, and I know there's a couple more poll questions. And then I'm going to take some questions, and Stella's going to talk, and then I'll stick around as long as I possibly can and answer as many as we have. So do you have any poll questions for the folks?
We do. That should be coming up, and then we will get to the questions.
All right.
Yeah. All right. If everybody would take a minute, take the poll.
You can't see my screen, right? You can't see my answers as I'm giving them?
No.
Because otherwise, if you guys are cheating, I'm gonna mark you down.
We can't see. All right. And let's all right. So sharing the results, and the answer is Jason.
I'm going to say suggestive. I mean, I think there's some debate to be had here, but I would say it's probably suggestive because it is suggesting something about the battery that is always ready to turn on whenever you need it. So it's not describing what the thing is, but it suggests a feature of the goods. That would be my analysis anyway.
Okay. All right, and we have one more, I think.
Or two more, maybe.
Or two, yeah. All right. Poll has started. And I hope you all do better than I did. I just got this wrong as we were preparing, so.
All right, good. Lots of good answers here. Yep, 10 years is correct. So it can be a little bit confusing because you do have to file the Section 8 between 5th and 6th years, but really the renewal is happening on the 10-year mark. So great job, folks.
All right. And last one here, and then we'll go to questions.
All right, this one should be an easy one. Let's hope so.
All right. And the answer is?
All right. Well, the answer is true. There is a requirement for mandatory electronic filing. However, if you answer false, I'm not going to mark you down on the test because there are very limited exceptions in which you can file on paper, and it's sort of necessary to file on paper. But for the most part, that's really, really rare, and it is mandatory that you file through TEAS Plus or TEAS Standard. So great job on those questions, folks.
Great. Thank you guys for participating and paying attention as well. All right, so I'm going to go to a couple here. One was about legal services. Jason did provide that resources for you. So the USPTO does not provide them, but he provided great resources. So question here, before doing this registration, can someone sue someone else for using their trademark? I think Lemar got his answer though. The answer is, can they sue? Yes. Okay.
Yeah, you can use so if you see before you've registered, or after you've applied, before you apply, if you see somebody who is infringing on your trademark rights, yeah, you could sue using your common law trademark rights. But they're stronger if you have a federal registration, and it's going to help you in court because it is prima facie evidence that you are the owner of the trademark, right? You can say, "Judge, look at this registration certificate; it's mine," right? And that's gonna help you a lot. So.
Okay. All right, and Ryan is asking about a brewer. This brewery wouldn't anticipate expanding outside of LA for like 5 years startup, but there isn't anything filed when he looked into the T system or being the USPTO. Would he have an issue filing his own trademark?
No. Look, you can file a trademark application on your own. Technically, there is no requirement that you have an attorney file for you. The only time that's true is if you are domiciled outside the United States. Okay, so if your business is primarily located outside the United States, or if you're an individual filing on your own and you're domiciled outside the United States, then you must have an attorney, U.S. licensed attorney, represent you. But otherwise, nope. If you are domiciled in the United States, you or your business, then you can file on your own. And even though you're not using it across state lines or outside the United States, I'm sorry, outside of the Los Angeles area yet, yes, you can go ahead and file, so long as you have a bona fide intent to be using it across state lines. So in, say, Nevada or Arizona or whatever, Oregon or Washington, right? If you're going to use it across state lines, or even if you're going to be selling, I don't exactly know what it is in terms of beer, what the restrictions are across about selling, say, online. But if you're going to be selling your stuff across state lines, that can be use across state lines. And that's use in commerce. So even if you're not technically expanding and opening up breweries in other parts of the country yet, but you're selling across those state lines, then you could absolutely file under the use in commerce basis. But you could also file it under the intent to use and just say, hey, USPTO, I'm not using across state lines yet, but I will be soon. And that's perfectly fine.
This is an interesting question. Theo asks, can I trademark a hashtag for my products or services?
That is a fantastic question. It used to be the answer was no, you could not. And the reason being that typically hashtags are used just to sort of like, for search on social media. And so it's not really functioning to indicate the source of particular goods and services. However, the rules have changed recently. And so long as that hashtag is being used as a trademark to indicate the source of particular goods and services, it is registrable. So what that means for you is going to come down to how are you using it? Are you just using it as like hashtag Jason's Donuts, right? On social, or are you using it as an actual brand that when people see hashtag Jason's Donuts, it's on the side of the van or it's on the website used in a very particular trademarky way, right? Or it's on, the thing you have at the farmer's market where you're selling your fresh donuts. Then it could. So it's going to really depend on use. And the examining attorney in the case is going to look at your specimens, look at your evidence to say, is he using it in a trademark way, or is he only using it in a hashtag find something on social media way? So it's possible, but like with domain names and like with business names and stuff like that, it depends on how you are using it on the evidence that you provide to the office.
Okay. And we're going to ask one more, and then we're going to go to Stella. So this one, quick leave, would I be able to register Disneylanders for my podcast?
Well, I am not allowed to give legal advice, so I am not allowed to answer that question. However,
I would say after working for Disney for 16 years, I probably wouldn't do it. Disney is very strong about protecting their marks in every area, whether you are the baker putting Mickey on there. I would be very cautious. That's a recommendation.
Yeah. And I would say, so again, I'm not going to give legal advice, but I think Colette is right on. And the other thing to think about too is there is a difference between use and registration. Okay, so it might be that you're able to register a trademark. Okay, and let's say that there is nothing in the database that's Disney related, has nothing to, they haven't registered Disneyland or anything along those lines. And maybe you're able to register it. Okay, well, that's registration, but use is a totally different animal. So it could be that even though you can register it, Disneyland and Disney might have common law rights in that trademark. And if you're too close to their stuff, they would still come after you and say, no, you cannot use our trademark because you're creating an association, makes it look like you're representing us or we're representing you, something along those lines. So those are two separate issues, registration and use. And you might be able to get away with one, but not the other, or you might get knocked down in both cases.
All right, so we're going to switch to Stella. Nicholas and Deserving, I see your hands up. You guys take your hands down. We're going to come back, and we will end formally at the allotted time, but we will continue on with questions. Jason has stated he'll be with us for at least another 10 minutes afterwards, so we're going to come back to your questions, okay? Thank you guys, so appreciate you. All right, Stella Mittelbach, it's all yours. And Stella's coming off mute. Uh-oh, Stella.
There we go. I got it.
Okay.
Thank you. Thanks, Jason. That was really great presentation. So helpful. So I'm a librarian at Central Library in downtown Los Angeles. My name is Stella Mittelbach, and our library is a patent and trademark resource center. So we're a part of a program that is a nationwide network of public, state, and academic libraries that disseminate patent and trademark information to the public. And so I get training from the USPTO once a year to help me answer people's questions. And it's one of my favorite parts of my job to talk to inventors and entrepreneurs that have questions about patents and trademarks. So we're in downtown LA. Right now we're closed for the pandemic. I expect we'll probably open up in some form in the next couple of months. We are offering, the curbside service. If you want to order books on patents and trademarks, we can, you can pick those up if you place a hold. And but of course, during this time, I am offering sessions by using Google Meet or Zoom or what have you. So I'd be happy to talk to any of you. We can set up an appointment. I usually talk to people for 45 minutes or an hour to answer whatever questions they have. But if it takes longer, I have the time, and I'd love to hear from you. So we're a PTRC. In addition to being part of this network of libraries that help people with patent and trademark questions, we have books like Patent It Yourself or other books from NOLA Press. There's one on trademarks that's really good. We have free little booklets we give out about intellectual property questions from the USPTO. When we're open, we have a couple of computer stations that people can use if it's just kind of first come, first serve. And, and we have librarians that can help you, find the resources you need. If you wanted to meet with me, one way to make an appointment would be to go to the lapl.org website, go to our homepage, scroll down to the bottom and look for this area that says connect with us. And there's a link that says book a librarian. If you click that link, there's a page that looks like this. You just fill out a form and say, what your question is, and it will, if it's about patents and trademarks, that's going to come right to me, and I will get back to you. And hope you do that. But you can, I'll give my email at the end if you want to contact me directly. We have a research guide, and I'm going to throw that link in the chat if I can find the link to the chat. It's not coming up for me. I'll throw that in later in the chat. But it has a section on trademarks that has the commonly used links that you might look for. Most of those links go back to the USPTO website. One thing, if you are an inventor, as well as, a business person, it's not part of our PTRC, but on the same floor as my department. So I'm in the Science, Technology, and Patents department. On lower level 2 at Central Library, we have a makerspace called the Octavia Lab, which has a lot of great machinery, 3D printers, a CNC mill, laser cutters, sewing and embroidery machines, a green screen. If you're doing maybe, an advertisement, you can use our green screen. We also have a few licenses of Adobe Creative Cloud. So once the library is open again, you'll be able to come in, use Photoshop or what have you, or edit a video using Adobe Premiere on our machines. So that's a great resource to use. You could also, use it for prototyping and invention if you need. Like the USPTO, we can't provide legal advice, but we can help you navigate intellectual property resources online and in print at the library. We offer those computers for you to use. We can print out forms for you if you know which form you need. And one of the main things that I do is show people how to perform a patent or trademark search using an example or using examples. And I do that by appointment. And we can't give out legal advice. We can't help you fill out the forms or applications. We can't tell you which forms you need. And we can't perform searches for you or suggest the specific terms you should use. We can't interpret government rules and procedures or advise how to respond to a USPTO action, office action. But we can sure help you, I can show you how to do a trademark search. We often, we have a handout we use called 7 Steps to, trademark searching. And this is also a 7 steps that you can find online, and I can show you how to do that in the appointment. So I can go over those steps and show you kind of different search strategies. If your trademark is a word mark, you want to look for anything that could be confusingly similar in sound, meaning, or appearance, as Jason said. So you may want to search for different spellings of your mark, sound alikes. So I use, in the examples that I use, I show how to do that search using truncation symbols, etc., and how to kind of think of different spellings. And then there's something called the ID manual that Jason mentioned, and I can show you how to use the ID manual to find out what international class you might fall into, or there might be more than one if you're selling different goods or offering different services. TESS is the Trademark Electronic Search System, and that's mainly what I will show you how to use if we make an appointment. There is also something called a design search code manual. So say if your trademark is words and an image of some sort or design, you can search for the design elements in your mark to make sure that image or that whether it be abstract or figurative, that's not in use. In a trademark that might be too similar to yours, that could confuse people. Yeah, so I show people how to use TESS and the design search code manual. And yeah, this is the example of one of the categories in the design code manual. So you can search by abstract symbols and whatnot, and I show you people how to do that. Yeah, so here's my email address. You can email me directly. You can email my department, science@lapl.org, or you can use that book a librarian link to reach me. And I'm going to throw it over to Colette and stop sharing it. And I'm going to put that link in the chat for you guys. Thanks for having me, and great program, Jason.
Great, thank you. And Stella, we have a poll, so related to Stella's presentation. So while she's putting the link in the chat, Priyajani, if you would please share that one, that would be great. All right. What is the Los Angeles Public Library's makerspace and central library called? You guys didn't even know there was a makerspace. I didn't know. That was new information for me. So it's a great resource for all of you creators as well. All right, 10 seconds. All right. And the answer is Stella.
Oh yeah, it's the Octavia Lab, and it's named after Octavia Butler, the science fiction writer.
Cool.
Very cool place.
Very cool. I did not know that. That's new too. All right, and we have a couple more. Go ahead, Priyajani. Go ahead. What's the poll? Great. Let's go. Thank you guys for participating. All right. And we're going to stop there. And I think Jason wrote patient, tireless, and reasonable.
Well, it's true.
Just funny feeling about that. I don't know.
Just trying to suggest that to people.
That is the PTRC. So thank you guys. And I think, Priyajani, do we have one more? Okay. No. Okay, that was all of them. All right. So I wanted to just share very briefly, and we're going to go right back to questions. Just about some of our upcoming webinars. We have Harold Hart-Niebrick is one of the attorneys on our team, and he has been helping clients through the disaster and then preparing. So if anyone is looking to get a commercial lease, I recommend taking one of these one of these monthly workshops, and never to be in a hurry to sign a commercial lease. And Harold can make sure to tell you all the reasons why and how you can prepare and be better prepared for the next time you're getting commercial property. So get some help. Then we also have Legacy Restaurants. It's a presentation with Jeanette Bolden Pickens. Jeanette is actually an Olympian from UCLA, and her family has 3 generations in the restaurant business. And so she's going to talk about the foibles and everything else of having a legacy restaurant with your family. It's different than just all hired employees. So for those of you that want to continue on your business, figure out how maybe you can eliminate some pitfalls as you hope to expand with your family. And then, as you all know, we have a whole list of webinars and workshops as well. Business plan, I'm hoping everyone is getting their business plans together. And PPP forgiveness, if you don't have PPP, holler, say something quick. Deadline is fast approaching. It may be extended, but it may not be. And we want you all to be able to be eligible and get all this money. Do not eliminate yourself. Go get this money. We can help. We have a workshop every Wednesday on funding, but this Wednesday is critical because of the deadline. And so these are the workshops here. You guys will get this presentation. You can always find these at pcrsbdc.org to take a look. So I just want to thank, and then we're going to go back to questions. Jason, thank you so much for very great presentation. I'm always taking notes and learning something myself here. Stella, thank you for coming back and being such a great resource for the city of Los Angeles. We really appreciate you. And we look forward to staying connected, and also with Jason as he's got other areas that he's working in as well. And then Julie Mason is working behind the scenes. She's a regional outreach officer. She reached out to us and has been coordinating this 3 series that we've done with the USPTO. And then Priyajani Sanders is in the background, making sure that all the stuff is working and that you can hear and see everything going on today. So we appreciate her in the background taking care of us. And I've got advisors and things on the call. And so we've got these advisors ready to assist you. So back to questions. So that will conclude our formal you got 2 minutes until the end time, and we're going to continue on to try to make sure that we can get to as many questions as possible. Except I just lost my chat. Okay,
can I throw out a resource real quick, Colette? I should have said it earlier on. So we have started what's called our Trademark Basics Boot Camp, and it is an 8-week series. You can attend as many as you want to, or like 1 to 8. And essentially, we talk about a lot of the things in the trademark registration process. The first week is essentially everything I talked about today. And in another week, we talk about searching. So like what Stella's talking about, like attend her stuff, attend week 2 of our boot camp, where I take you through tests and also show you mechanics in searching. We talk about application requirements. In week 4, I do an actual walkthrough of the trademark, the initial application form, show you how to fill out the thing. And then it sort of like gets a little bit more advanced from there. But it's our Trademark Basics Boot Camp. It's totally free. Let me open up the chat. I'll throw the link in there. And you can feel free to, let's see, everyone. There you go. To sign up to attend, and we'd love to have you there. It's a free webinar. It's on Tuesdays. It's 11 p.m. Pacific. So
11 p.m. Hopefully AM, right? No, not hopefully.
It's 2 p.m. Eastern. It's funny. I've lived out here in LA for like 12 years, coming from the East Coast, and I still have trouble making the conversion.
I'm like, man, those East Coasters are staying up late to get knowledge. All right.
Look, they party. It's 2 a.m. You got to talk trademarks.
Yeah. All right. So a few questions we're going to go. Do we get the filing fee back if we get rejected?
Nope.
No, you do not.
Sorry, I don't mean to come across as cruel. It is an application filing fee, and essentially what the fee pays for is the examination of the application. So what you're paying for is to have the examining attorney do that, and plus all of the professional staff and all those sorts of things. So unfortunately, you do not get the fee back.
Okay. And then someone was asking about one class, different fees. Like, do you have to apply for, what was it, different marks? Are there separate fees, or are they all inclusive?
Let me try and break that apart a little bit.
And I was going to say, somebody had, I think, a similar question related to Coke in here, where they're asking, hey, Coke applied for for beverages, but now they put their names on the T-shirts. So different, same mark, different uses.
Great. Okay. Great. So let's take Coca-Cola as an example. Okay. So Coca-Cola has a lot of money, right? And they can protect as many trademark versions of their trademark as they want to. All right. So they can protect Coca-Cola as the standard character drawing, right? As that word mark. They can protect it stylized. They can protect it as part of a composite mark. They can protect it as part of a design mark. It is up to them how many of those applications they want to file. You can file as many as you want to. The only restriction is you can't file exact duplicates of the same thing, right? So if they wanted to, they could file trademark as the word mark for soft drinks. They could also, in that same application, also protect it for T-shirts and hats and socks and whatever it is that they have at the Coke store. And they could also protect it for bottling services and also for transportation service, whatever it is. And they can put all that stuff in a single application, right? For Coca-Cola for that word mark. Now, granted, the cost is going to go up because there are different international classes that are involved. So soft drinks would be in one, the clothing articles would be another, bottling services would be in another, transportation services might be in another, right? So all of those things, and they can pay for all those things. If they also wanted to register Coca-Cola for those exact same goods and services, but they want to do it for Coca-Cola stylized in red, yep, they can do that. That's just a separate application. They also want to protect all those goods, the use of the mark with all those goods and services for the composite always Coca-Cola mark. Sure, they can do that. And they could do that one in color if they wanted to. They could also do the same thing in black and white if they want to, right? So what I'm trying to get at here, it is really up to you to figure out which version of your trademark you want to register. Protect the wording alone to get that broad protection, or do you want a little bit narrow protection by registering a stylized or special form sort of version of your trademark? And it is up to you to choose which goods and services you identify in your application. You don't have to identify all of the goods and services that you use with your trademark. You could if you wanted to, like, oh, Jason, I have $250, but I know that I have stuff in that are 2 different international classes. I can't afford to do both. Well, no problem. It is up to you to choose which one you want to do, right? So you could register it for just the soft drinks, or you could register it for just the clothing. It's totally fine. And later on, you get another $250 and you're like, yes, Jason, I'm ready. Well, you can file another application for that exact same trademark, but for those other goods that you didn't include in the original application. Does that unpack it a little bit anyway?
And so Deserving the Best here says registered trademark that is showing is dead. What does that mean? How do I resurrect it?
Great question. So what you're talking about there is when you're doing a search in tests, you will see that some trademarks are live and some marks are dead. And a live trademark just means that the application or registration is still ongoing at the office. And something is either happening with it, or it has been registered and it's still alive and they're still filing their paperwork. A dead application or a dead registration means essentially what you think it means, right? That the application or registration is no longer going forward. Now, it's a little bit tricky because if an application could die and go abandoned because a person didn't file the proper paperwork in time, but they have 2 months in order to revive that application. So an application technically could show up as dead in our system, but then turn back to live as soon as they resurrect that application through a petition to revive. A registration is not going to show as dead. When a registration shows as dead, it's essentially dead. There is a grace period in which you can file your paperwork, a 6-month grace period if you missed your filing. But once it passes that 6 months, it's dead. So essentially what that means, dead means in the system is it's probably done, right? That means that application or registration is not going to move forward. Now, the one thing I would caution you though, is just because it shows up as dead in our system, that does not mean that you're in the clear. Because remember, there's a difference between use and registration. And it could be that the registration is dead, but the trademark is still alive and that company is still continuing to use it and they might have prior use rights. Like let's say Levi's never registered Levi's as a trademark for their jeans. Okay. And so, right. And so they never did. So they have all of these prior use rights from 1870, whatever, whatever they found in the company. And so they have really strong rights. So if at one point they did register one trademark, but they let it go dead and that showed up as dead and you saw Levi's dead in our database, would you want to try and use that trademark? No, because Levi's is still alive and they're still kicking and they will still come after you and they will essentially sue you to stop using it. Okay. So just because it's dead in the system, it might mean that trademark is available kind of, like no one's using this anymore. Yeah, maybe you could go ahead. That is really just a trigger to go do more research. Is this company still around? Are they still using that trademark as a trademark? And if not, maybe it's something you could think about, but keep that in mind. It's a warning sign anyway.
Right. So let's see, can we get okay. Yes, the presentation, you guys should receive the link to this. And if not, we are going to put this in our email system as well. So someone here says, my aunt inherited a shampoo business with a registered trademark and another company started using her name, art, everything. She took them to court, but they continued to use her name and she eventually ran out of money fighting them. If that can happen, what good is having a trademark?
Oh, interesting. Well, first of all, I'm very sorry to hear about that. That's not a situation that is good for anybody. So there still are benefits to having a trademark registration. Just because in this particular circumstance, it didn't work out. That doesn't mean that all other trademark registrations are therefore worthless and invalid. It just means that unfortunately it didn't work out in that particular situation. But there are still a lot of rights that are created through trademark registration. And even though there is perhaps no evidence of it, you might think about the fact that there could have been other people who were going to infringe upon that or wanted to use the same or similar trademark. And so the fact that the business had that registration meant that those other businesses didn't infringe. So that is more money that was saved because you didn't have to fight off all of those other companies. And the other thing that you might want to think about is that the fact that you have a federal trademark registration in the database even though we as the USPTO do not enforce your trademark rights, I like to think about it as we're kind of a first line of defense. And if we think about the likelihood of confusion analysis and the pop quizzes that we did earlier today, that's really that first line of defense. So it could be that the company has that registered trademark and other people start to apply to try and register similar trademarks. The USPTO rejects those other folks, right? So if you didn't have that registration, all these other companies might be going live and they might be, sort of infringing on your particular trademark registration. So the USPTO is sort of like stopping that stuff from happening, right? And is not allowing these other companies to get nationwide protection for their marks, which could be similar to yours. I mean, because the opposite could be true, is that if your particular business wasn't registered and these other folks came in, registered a same or similar trademark for related goods and services, they might be able to say, hey, you original user need to stop because look, I have a registration. Okay, so there are lots of potentially things that were avoided by having that registration. But please understand, I'm very sorry to hear about that. It's always tough to hear about this situation. So I feel your frustration, and I'm very sorry to hear it.
Thank you. And then Louis, and I think this will be our last one here, is I've already done my trademark research and I didn't find anyone else using it. Would the next step be to get an attorney?
It could be. Yeah, it could be if you want to. The attorney is going to do a lot of that, is probably going to redo some of the work that you did, just because that's what that's how attorneys operate. So an attorney might do that. You could, if you wanted to, talk to an attorney to hire someone to help you with the application. Then again, you could also do it on your own. We always, at the USPTO, we always recommend you work with an experienced trademark practitioner, because there are those pitfalls. There are those things of how do I define exactly which my goods and my services, and what basis do I use, things like that. An experienced trademark attorney can help you with that. But you apparently, it's very clear, are an intelligent person you are perfectly able to educate yourself, and you would be able to fill out the form by yourself and file for registration on your own. You are perfectly welcome to do that. When I was examining, there would be times when I would see an application that was filed by someone not represented by an attorney, what we call a pro se applicant, and it was perfect. Everything was great, and I could just sort of rubber stamp the thing and get it moving, moving on towards registration. And then there would be another application filed by some attorney who had no idea what he was doing, and it was just a mess. Okay, so you have to be very careful when you're hiring someone. So you want to make sure you're seeking out somebody who knows what they're doing. So you're going to be if you want to hire an attorney, great. You could check out some of the resources you'll find the links in the PDF of the slide deck that's going to be sent to you through it's called INTA, the International Trademark Association. They have a pro bono clearinghouse where you can sort of get help for free. The American Bar Association has lots of pro se resources where you can get help for free. The Law School Clinic, you can get help for free if you don't want to necessarily pay for it. The one thing I would say though, is please be careful of what are known as trademark filing companies. I'm not speaking ill of them. I'm saying that they serve a very specific purpose, which may not be helpful to you. Okay, so what a trademark filing company does, and you'll see them advertised online all the time, file your trademark for X amount, whatever. Essentially, all they're doing is filing your application for you. They're doing something that you can do on your own, and they are charging you for the privilege of doing it for you. Okay, so what you have to be careful of with some of these companies is be aware that they are not providing legal advice. They are purely just filling out a form for you and submitting it. So if you do want to use one of these companies, please make sure that you're using a company that is going to have an attorney that is going to be working with you, or is going to be reviewing your application, or talking to you about what it is you're doing, and what a specimen is, what a good specimen is, stuff like that. Because you want to make sure you're getting the benefit of that legal counsel if you're going to be paying someone to file something for you. Because remember, the only people who can file a trademark application would be you as the owner, or an attorney who is representing you. You cannot have I'm sorry, other people can file, but in terms of representation, the conversation that happens between the USPTO and the trademark owner is only going to be between the USPTO and the owner, or the USPTO and the owner's representative. The USPTO is not going to talk to that filing company. So if the filing company does something wrong, messes it up, well, that's not on the filing company. We're going to be talking to you because you're the trademark owner, and it's going to be up to you to fix it. So that's a really long way of me talking about all these things. But keep in mind, yes, if you can hire an attorney, that's awesome. But also if it's going to be too tough for you and where your business is at this time, you can do the research, you can figure it out on your own, and I'm sure you could do a great job with it. So please don't be scared off from doing it on your own, but just make sure you're educating yourself like you're doing by working with SBDCs. So.
Yeah. Well, thank you so much. Again, Jason, Stella, we so appreciate you all. Thank you all for staying on, getting those questions. I know we're not able to get all of the questions answered today. However, we do have a legal advisor who is very helpful in the self-service side and to direct when you need a lawyer and when we can help you from an SBDC perspective. So when you work with your core advisor, when you're ready, then you can see the legal advisor. You have Stella, who's provided her information, so you can get your research done and get some additional resources here. So you guys are using your resources, being good business owners, and getting all the information that you need to go forth and save some money along the way as well. So we appreciate USPTO and the PTRC, all these acronyms, but now you all know what they mean. Let's go forth and use them. Everybody have a wonderful day. Thank you all for joining us today at PCR SBDC. Have a wonderful afternoon. Thanks again.
Thank you.
All right. Bye-bye.